Hello students, there is a good news for you. Now you can write the same matter at different speeds. Link of the same is given in the description box. Thank you. Start. Whether a copy of the plaint in a suit pending before a civil court can be treated as reliable evidence as required in section 137 of the Code of Criminal Procedure is the short question to be considered in this criminal revision petition. Stop. To challenge in this criminal revision petition is against the order dated 9/6/2010 in file of the subdivisional magistrate, which is a proceeding issued under section 138 of the CRPC. Stop. For better understanding of the above question, the necessary facts involved in the above revision are absolutely inevitable, which I shall now refer in brief. Stop. Para. The petitioners, 4 in number, are the counter petitioners in the above proceedings. Stop. The respondent numbers 1 to 5 herein are the petitioners in the said proceedings who approached the court below by filing a petition under section 133 of the CRPC alleging that the revision petitioners herein have interfered with the right to public pathway having a width of 12 links. Stop. Para. On the appearance of the respondents, they have filed a counter affidavit in the above revision petition, along with which they have produced annexures, documents, and also a petition to vacate the interim order issued by this court. Stop. During the pendency of the above criminal revision, the petitioners in the revision petition have preferred criminal miscellaneous application to receive the documents which are produced along with the said petition and marked as annexures. Stop. In the above petition against the prayer to accept additional documents, the third respondent therein had filed a counter affidavit along with which the third respondent has produced an annexure report of the Tehsildar along with the location map submitted before the revenue divisional officer in the above proceedings. Stop. Thus, the pleadings are complete. Stop. Para. As indicated earlier, the respondents herein preferred petition under section 133 of the CRPC, which is a petition dated 14/2/2005 alleging that the petitioners herein obstructed 12 links public pathway by erecting pillars and fence and thereby reduced the width to 6 links. Stop. The petitioner herein preferred objection disputing the existence of the public pathway. Stop. Thereafter, the subdivisional magistrate passed the order holding that the disputed pathway is a private property and the dispute does not come within the jurisdiction of the learned magistrate. Stop. Challenging the order, the respondents herein approached this court by filing writ petition and criminal revision petition and this court disposed of the above writ petition as well as the revision petition by a common judgment dated 28/2007, a copy of which is produced in the counter affidavit of the respondents. In the said judgment, this court directed the subdivisional magistrate to proceed on complaint in accordance with law and set aside order of the subdivisional magistrate. Subsequently, the subdivisional magistrate dismissed the petition filed by the respondents. Against the said order, the respondents herein had also preferred contempt case. Thus, as per common order, this court has observed that the subdivisional magistrate has failed to pass a conditional order in terms of section 133 of the CRPC, and the order passed by him pursuant to the remand by this court cannot be supported, and thus the same is set aside. This court has also observed that it would be open to the petitioners herein to appear before the subdivisional magistrate and raise all contentions available to them on receipt of the conditional order. This court has also directed the learned magistrate to pass the conditional order in terms of section 133 of the CRPC within 2 weeks of receipt of a copy of that order. Thus, in pursuance of common order and in terms of the directions contained therein, the subdivisional magistrate passed order.